court rise in favour?
Now, Ms. Carrigan, I think we're making good progress, and I don't, I'm not rushing you, but I don't anticipate you're going to be that much longer. But if I can just say, we need to rise no later, including after reply, by 10 to 4.
Yes, my lady, I'm grateful. For an estimate of time, I'm probably not going to do much more than 20 minutes. A lot of what you say is already in my skeleton.
Yeah, it is, and we're very grateful for that. So just, we don't want to rush you, but I'm
grateful, my lady. Thank you.
Now, we were moving on to factors relied on.
Yes, my lady. In respect to factors that were taken into consideration, so this is my submission 4. In effect, the submission is that Mr. Justice Jacobs took into account a variety of different factors, and in doing so produced what is, we say, a well thought out and robust judgment on a case management decision, and as such, in light of the authorities on case management decisions, it should be lightly intervened with. The judgment, as you're well aware, is at the core bundle at tab 7. However, if it is of assistance, I have addressed it within my skeleton argument, paragraph 29.
Paragraph?
That's contained at tab 3, core bundle. And in particular, it's page 36.
36.
Yes, my lady.
Thank you.
Namely that Mr. Justice Jacobs took into account 11 factors. I'll outline those, but in respect of the references to the judgment, I am content to leave them as they are stated in my skeleton. So those reasons being the admission, the merits of the claim, the effect of the strikeout on the advancement of the claim in the future, the fact that there was a serious breach, that there was no good reason for it, the late service of the particulars of claim, that the mistake was not one which was fully and frankly admitted to, at least for some time, that there was a lack of immediate action by the claimant's previous solicitors, the need for litigation ultimately to be conducted efficiently and at proportionate costs, the additional non-compliance and the criticism that my learned friend raised of the claimant's pleadings. As such, given those factors, as I say, I don't seek to take to those paragraphs in the judgment. They are referenced in the skeleton argument for your note. We say it was a well thought out and thorough judgment. And unless there's anything in particular on those factors, I propose to move on to the fifth submission, which is really detailing the response to the first round of appeal, namely that we say Mr. Justice Jacobs' decision was correct. You have within the core bundle the grounds of appeal. I appreciate my learned friend has already taken you through that. The first ground being essentially that the judge has directed himself. For reference, if it is any easier, again, this is addressed at paragraph 63 of my skeleton argument, and that's contained at page 47 of the core bundle. Again, I don't seek to go into much more detail than what is there. The first point being that the court, as I've already taken through the authorities, in assessing all the circumstances of the claim, is allowed to take into account the party's merits. There's no debar on that. The second point being that in taking account of that, the court must not embark on a detailed investigation. And Mr. Justice Jacobs acknowledged that within his judgment at paragraph 31, for reference in the core bundle, that is contained at page 80 behind tab 7. It's a passage that you've been taken to quite frequently within the proceedings, so I don't seek to go into the proceedings that have already been gone through. The third point being that whether or not a judge is able to consider the merits of the claim without embarking on a detailed investigation ultimately will be case specific. Here the judge was primarily concerned with the pre-action admission having been made by experienced loss adjusters and then withdrawn without an explanation as to what that possible defence could be. And again, the judge acknowledges that at paragraphs 52 and 53 of his judgment for reference in the core bundle. That begins at page 84. In particular reference, just to draw your attention to paragraph 53, the fourth line from the bottom, it is possible to do no more than to speculate as to what the defence on liability might be. It's acknowledged there, we say, that the judge is making, is aware that there is no defence currently before court and can only go so far as what's before it. The fourth point is that the overriding objective is engaged in dealing with applications for relief from sanctions, and it seems therefore only logical that if we're looking at cases where they can be dealt justly and at proportionate costs, to deal with merits. The idea of dealing with merits in effect is not something that's unusual, albeit it should be limited, but that is in line with the case law. Again, I don't seek to go any further than that. Aside from to say, we say in this instance anyway, based on the documents before the court, it doesn't require much exploration for a judge to state that in its current position, the claim seems to be a very strong one. Again, attempting not to repeat myself. There are circumstances where the consideration of the merits of the claim may be quite appropriate. So, for instance, and I appreciate sometimes the proportionality of a sanction is dealt with at the sanction stage as opposed to at the relief stage. But nonetheless, for instance, if an individual had a very strong claim and missed a deadline that didn't result in, say, a trial date, or there wasn't much disruption, then in those sorts of instances, the balance is more looking toward that a strikeout would be disproportionate, and here it is ultimately the strikeout of a claim, which is the result of the relief, the result of there being no relief from sanction. But again, it is going to be case specific on that.
So we've got your detailed
Yes, I don't
paragraphs in relation to ground one.
Can I just ask you something on that? It's the last sentence of paragraph 29 of the judgment, which is on page 80, where the judge has just cited the Global Torch and Highsage cases,
Yes.
which appear to say that you don't look at the merits unless it's either very strong or very weak, says Lord Justice Morbick, and that is then equated with a case which would satisfy the summary judgment test. So I'm a little unclear why Mr. Justice Jacobs says that he, that's Lord Justice Morbick, does not go as far in the context of the application of the Denton principles to say that it would be necessary for a summary judgment application to succeed. That's the passage relied on by Ms. Boone, as I understand it, to submit that the judge was applying a lesser test than summary judgment to his assessment of the merits. So I'd be grateful to know what you say about that.
Yes, my lord, I'm grateful for the question. In respect of the threshold being lower, which is my learned friend's argument, we say that in any event, paragraph 29 is consistent because in respect of summary judgment, it is phrased, and I'll give you a moment just to find the passage, but summary judgment is one of the possible exceptions. It's not necessarily the only exception. And therefore, given that it's not the only exception, if there is going to be anything further to that, what summary judgment in effect is doing is saying, well, there's a very strong claim here, therefore we'll deal with it summarily, and that's essentially what Mr. Justice Jacobs here does.
Is there any difference between what was said at paragraph 47, which was, in cases where an application for summary judgment could be expected to succeed, it's that in contrast with what the judge here said, he doesn't go so far as to say on the application's end it would be necessary for it to succeed, or is that simply splitting hairs? Is there a difference between an expectation, or is the judge saying an expectation isn't as far as necessary? Or is that dancing on a pinhead?
My lady, one minute, if I can just take the passage.
Yes,
and hide it.
do.
My apologies.
I'm sorry.
My apologies.
It's in your authorities at page 117.
I'm grateful. Melody, in respect of could be expected to succeed, it may be that it's phrased in such a way because these are applications where there is no summary judgment application before the court to determine. As far as I'm aware, there was none present in the high side case and there's none present within our claim. So the expectation really can only go so far. Now it may be that as it's an expectation, and these are applications which are not before the court, that the judge can only go so far in respect to the materials that is before it, and therefore not the materials that are necessarily expected before it in the summary judgment, in a summary judgment application. Therefore, to go in respect to could be expected to succeed, here a summary judgment on the papers could be expected to be successful because there is the admission, the withdrawal, and then the lack of explanation. So perhaps really it goes to the fact that the expectation is looking at what the case is before the court now and not what the case could be.
Thank you.
Great.
I suppose, picking up my lady's point, another key phrase from paragraph 46 of High Sage may be the court can see without much investigation. So it's not the sort of thing you're expected or required to go into very deeply, in contrast with a summary judgment application where you would go into it deeply to see whether there's a real prospect of success or not.
Yes, my lord, I'm in agreement with that.
Yeah. Okay.
Thank you.
Thank you very much.
Can I just pick up, in fact, 2 points. One, just a matter of linguistics. If you've got page 93 of the authorities bundle, which is Global Torch, paragraph 29, I think you actually said a couple of times, and certainly recently, that the question of whether somebody's entitled to summary judgment is just one possible exception. But actually what Lord Neuberger says just at C is the one possible exception could be. Then he talks about the general rule and the exception. He does seem to be envisaging, as far as I can see, that actually the only exception is if you have a case which is strong enough to get summary judgment. I mean, would that be a fair reading of it?
My lord, I don't think we need to necessarily go that far. I think it's a fair reading to say that summary judgment is definitely considered as an exception. I think the fact that it mentions the one possible exception.
I think my lord. I think my lord's more concerned with the word "the," which suggests that the only exception would be the summary judgment exception, as opposed to it being one of a number of possible exceptions. I think that's right.
Yes, it is. I mean, again, to answer my own question in perhaps another way, it is suggested a little bit further down the paragraph that Mr. Fenwick seemed to be inclined at one stage to suggest the exception might be a little wider, and Lord Neuberger doesn't go on to say, but he was talking nonsense or otherwise. He doesn't squash it, so it seems to be a little bit flexible.
Yes, I'd agree with it being flexible, given that the test is all the circumstances. I think to restrict it only to those cases where summary judgment would be applicable, maybe going too narrow, and then we would be diverting beyond the wording of 3.9 itself. Though I do appreciate that, and I think it's correct, that in dealing with merits under all the circumstances, it's not one that necessarily is readily engaged with the courts.
The second and sort of follow-on question is this. I mean, throughout this entire hearing and no doubt in front of the judge. People have been talking about there being a sort of a strong case, a very strong case, an irrefutable case. But this was a case in which the admission as to liability was made at a time when, as we know, the quantum of the claim was said to be much lower than it developed. To what extent, when one's talking about the strength of a case, can the court take into account, when it's exercising its discretion, how strong the case is for what amount? Because when I put it to you this morning, you just said, well, it's a sort of, this is just a strong case on liability, as if that could be completely divorced from the question of quantum. Can the court take into account, when it's deciding whether to grant relief from sanctions, that, for example, this is a very strong case, but for Top and Tapenny, or a very strong case for £20 million?
Well, to address the first point in respect of quantum, my understanding is instructed that the claimant was under the impression that the quantum was going to be more than 30,000 anyway. Maybe that nothing turns upon that, it's not really the big issue. In respect, however, of whether or not a court can really divorce essentially the liability aspect and the quantum aspect, I'd submit that it can be done. There are cases which will go to court where liability has been accepted, but there isn't an agreement between parties as to what the quantum is going to be. For instance, say in a housing disrepair case, for instance, it may be liability is accepted, but then there's a subsequent disposal hearing which deals with whether or not there's certain works that need to be carried out, or whether, or again, just the actual quantification of quantum itself. It
may be my fault. I haven't really put the question well enough, perhaps, but just to give you this example, there are cases where, for example, there's a serious and substantial delay and no good reason given for it. And the claim, when you look at it, is perhaps a strong case, but only for £10,000. There are other cases where, when you look at it, it looks to be a strong, very strong, whatever case for, as I said, 20 million. Does that make a difference to how the court approaches, quotes, all the circumstances and the offset against the seriousness and substantial delay and the no explanation?
Yes, my lord. In terms of the risk of sounding quite vague, I think it may very well turn upon the case in question. I think here, in respect of when we look to liability, there is still here a case, and a strong case on liability, regardless of how many, say, points of liability will be met, is slightly different. And when we look to the context of this, which again comes back to that this is an application which would have essentially rendered the claimant's claim finished. When we look to that, knowing that there is a very strong claim on liability, yes, there may be some sub-points that fall apart, but it doesn't change the fact that there is a case to be answered to by the defendant on liability. I'm not sure if that's this.
Thank you.
Thank you.
I'm grateful.
Are we on to ground two, or if you...
Yes, my lady. I don't think it's going to add anything more than what's in my skeleton argument.
No, and we've got your skeleton argument, which we can reread.
I'm grateful, my lady. In respect of ground two, again, this is addressed within my skeleton argument. Page 65. In the building of the page 49 of the core book.
Well, I'm not sure, with respect, that does really address, at any rate, the way in which Ms. Boone put it very clearly this morning, which is that it was unjust, see paragraph 34 of Global Torch, for the judge to go into the merits at all, because your side, your predecessor, had not given notice that that was going to be an issue at the relief against sanctions issue. Now, if you think you've dealt with that somewhere in paragraph of your skeleton, then direct us to it, but I'm not sure that's addressing quite that point.
Yes,
So I'd very much like to know what you say about the argument we heard this morning.
yes, my lord. The first point really is that in respect to my skeleton argument, given that Miss Boone's grounds of appeal don't detail having not been known about the merits of the claim within that ground too, that's why it's omitted from that part of my skeleton argument. In respect, however, of not being aware of it, I think I took you before to the application notice itself and through to the witness statement. And again, I do accept it is not the clearest statement, but it is clear from that the admission is in dispute, and what was specifically raised. Get the page reference now for you, might be a moment. I've taken you through the application notice now, so I don't seek to go much further, aside from to say that in relation to section 3, that the further defendant is stopped from defending the claimant's claim on the basis of a previously open admission of liability. And if I take you through the accompanying statement, it begins at page 122. We have paragraph 58 of that statement, page 129, which details in respect of all the circumstances of the admission being dealt with below. And then what we have at paragraphs 59 through to essentially 89 is detail about the admission that the claimant solicitors seek to use. So, for instance, at paragraph 90 at page 133, in any case, if the court considers the admission indeed cannot be reconsidered. Apologies, I'll not be a moment. At paragraph 84, at page 132. Apologies for jumping through the bundles. Stated that there has been no change to the factual circumstances of the claim or to the facts as known to FM Conway and being the first defendant. It's clear within that statement we say that merits are going to be brought up at the hearing. Indeed, we say that must be clear because the witness statement in response from Mr. Cook that begins at page 190. Particularly at page 195. We have at paragraph 17 and 18 detailing as to why the first defendant does not consider an argument in respect of being stopped from a claim, stopped from defending a claim, is relevant to the claimant's application set aside the order. And again at paragraph 18, prior to my instruction and my first-hand knowledge, I understand that the first defendant's loss adjuster, at a time when the first defendant was not legally represented, mistakenly admitted liability. The fact that it references the mistake to liability, which is a mistake which wasn't referenced within the withdrawal itself, we'd say is indicative of the fact that merits of the admission were in the minds and forefront of the solicitors of the first defendant. In any event, when an individual is seeking to rely on an admission and those documents and withdrawal of its admission, it's not so far removed to presume that merits are going to be brought up as to the circumstances of that withdrawal, particularly in circumstances, and I do appreciate my learned friend's position in respect of that the law being applied was going to be incorrect, but it was a matter in dispute as to whether or not the admission had been validly withdrawn, and if so, if it hadn't fell within, if the contention was incorrect, that simply to withdraw the admission is enough, and there would have had to have been some sort of assessment by the court into the merits of that.
Thank you.
I'm grateful. Aside from that, in respect of the decision being unjust, you do have my points at paragraph 66
Yes.
of my skeleton argument. I am content with those unless you wish me to go into any further detail.
No, those are detailed and helpful, thank you, with the relevant references marked in.
I'm grateful. Unless there can be of any further assistance in respect of ground 2, I'll go to ground 3.
Thank you.
Okay, ground 3 is detailed from paragraphs 67 to 68 of my skeleton argument, and again that's contained within the bundle at page 51. Namely that Mr. Justice Jacobs correctly exercised his decision. And again, aside from to repeat those points in my skeleton argument, namely that he's taken into account all the circumstances of the claim, the importance that this is a pre-action admission, which on his finding did not have a factual explanation as to its withdrawal. The fact that the claimant is exercising a genuine right to a claim in circumstances where we say the defendant hasn't provided any real detail as to how it intends to defend the claim. It was open to the defendant within its withdrawal email, and it indeed is quite an in-depth withdrawal email, of detailed as to why it has now changed its position in respect of liability, and it isn't really just to do with quantum. Unless I can assist any further in respect of those submissions in my skeleton argument, I don't intend to go any further.
Yes, well, I'll ask you the same question I asked Ms. Boone about the mediation point. Do you have anything to add to what she said?
My lord, I don't. I do accept that there has been the £30,000 cost order paid. There is interest on that. My understanding is that interest is following pretty soon. It's not that that's not going to be paid, but aside from that, I cannot assist any further.
No. All right, thank you.
I'm grateful.
Thank you very much, Ms. Corrin.
I'm grateful.
Yes, anything in reply?
My lady, I have 6 short points, very short, in reply. The first is, what was the claimant arguing at the relief from sanctions application? And we can find that in Miss Berzio's skeleton argument in the supplemental bundle at page 270. In relation to the relief from sanctions application, Miss Berzio's submissions relied entirely on the fact that the admission could be relied upon. And we can see that on page 270 of the supplemental bundle, starting at paragraph 15. If we turn over the page, contrary to a submission made by my learned friend earlier, Miss Berzio was relying on the post-October 2023 rules and was relying on 2 decisions, Woodland and Wood, which we can see at paragraph 17, which were pre-October 2023 decisions in any event. But we can see at paragraph 21 that she submitted, D1 has failed to make an application for permission to withdraw. Until that time, it is an admission upon which C and D2 can rely. And at paragraph 22, as D1 has admitted liability for the claim and has not applied to withdraw it, the outstanding matters in relation to D1 is the quantification of damage. If the strikeout is to be maintained, D1 obtains a significant windfall against the claim which has admitted liability. Now, the paragraphs to which my learned friend refers you to in the witness statement of Mr. Hall and Mr. Cook don't go any further than the admission, whether or not it was or wasn't right to withdraw it. And in fact, I deal with that at paragraphs 45 to 47 of my skeleton argument, which can be found in the core bundle at page 27.
You mean your skeleton argument for this hearing?
Yes. Thank you, milady. Behind tab 2 of the core bundle, at page 27, paragraph 45, I submit the claimant's argument proceeded solely on the basis that she could rely on the admission because it had not validly withdrawn. The judge found that to be incorrect. At no stage did either the claimant or the judge identify that the first defendant had to answer any suggestion that its claim in negligence was weak on the merits and or that the claim had an unanswerable case. Accordingly, the judge's finding that the admission, together with the lack of defence, meant that there was somehow a very strong case was clearly, in my submission, erroneous and unjust. The claimant's claim is one in negligence, and in order to consider the merits of a claim in negligence, in my submission, one would have to look at the pleadings, the witness statement, and the evidence. Now, that is turns.
Sorry, can I just?
Of course, my lord.
But actually, I'm not sure the point you've just made helps you. If in fact, as you point out at page 271 of the supplemental bundle, Ms. Corrigan's predecessor was erroneously relying on the current CPR, where you have to get the consent of the court to withdraw, then the merits could be expected to be in play, couldn't they?
No, my lord, I don't accept that. The argument was whether or not the admission could be relied upon or had been validly withdrawn. That is something that was dealt with before the judge at the relief from sanctions application. At no stage was there a separate argument, admission aside, that the claim in negligence, as pleaded in the particulars of claim, was one that was very strong or very weak or was an unanswerable claim. And of course, there was, in fact, no discussion at all, either in argument or in the judge's judgment, as to whether or not the claim in negligence, which requires breach of duty, causation and loss, was very strong or very weak. We can see, and that is my third point, that the two, the admission and merits, were not dealt with separately by the judge. The judge did not say, there was an admission on liability that has been withdrawn, and that is a fact I can take into account. But nevertheless, the claim in negligence, as is pleaded in the particulars of claim, is one which is very strong or unanswerable. There was no discussion at all as to the merits of the claim. The judge equated the two, and he found, and I will take you through the relevant paragraphs, but he found that because there had been an admission, as a matter of fact, and because there was an absence of a defence before the court, that meant that the merits of the claim were very strong. Well, in my respectful submission, the merits of the claim is a question of the claim as pleaded in negligence. The merits of the claim in relation to an admission that has been withdrawn, and in circumstances where there wasn't a defence before the court, those are not two things that the judge, in my view, could and should have equated.
Well, his conclusion on the merits was ultimately a combination of three factors. One was the admission, another was the fact that the property had been inspected and found to be fine, and then the rain came through immediately after the work, and the third was the absence of any defence. So all of those together were what ultimately led him to say that on the material before him, recognising that things might change, it was a very strong claim.
Well, my lord, if I may, one, the admission, and two, the merits, I say, are not factors that he should have taken into account. Two, the effective res ipsa loquitur case, that this is a claim in negligence, and we can see from the particulars of claim, which are behind tab 9, that of course it's not sufficient for the claimant to simply stand up and say, in a claim in negligence, you carried out some resurfacing works, and my vault may or may not have suffered damage. Of course, the claim as pleaded behind tab 9, at page 97 of the bundle, it's for the claimant to establish that my client was negligent, and she sets out a number of ways in which she alleges that they were negligent: failed to carry out appropriate risk assessments, failed to provide adequate advance notice, failed to give the claimant sufficient opportunity, failed to carry out the works with reasonable care and skill. But in my submission, that is not the same as simply saying, even if at its highest it was correct that the claimant's fault was fine before the works and wasn't fine after the works, that nevertheless the defendant was negligent in carrying out those works. There was no discussion as to liability, and on the pleaded case, which is one in negligence, there is no allegation that my client was simply strictly liable for the damage just because damage was caused. It's a claim in negligence, and a failure to fall below a reasonable standard of care and skill on behalf of the contractor is something that the claimant would need to establish. So, my lord, I accept that the judge may have taken into account a third factor, which was res ipsa, but in my submission, that's not assessing the merits of the claim.
That wasn't saying there was strict liability. That was saying that when people do work in the road, that shouldn't cause leakage to come through properly tanked premises. And the fact that it does indicates they didn't do it properly in some way. So he wasn't saying there's strict liability. He was just saying the fact that it happened is strong evidence that it wasn't done properly.
Well, my lord, that might be the case. I'm in a slightly difficult position because, of course, on the one hand, I didn't have a defence or the fact or legal basis of the defence before the court in the relief from sanctions application. And that is something which the judge took into account, the absence of a defence. I now appear before you today, and of course I do have a defence sitting in the bundle at tab 10, where it's slightly in this dancing on the head of a pin, where on the one hand I'm making this submission, there was no evidence before the court as to what any arguments might be on liability, and of course there is a defence that has been filed. That wasn't evidence that the court could take into account at the time, but that is, with respect, rather my submission, which is, in the absence of a defence, having not got to that stage, the judge in a claim in negligence was not in a position to assess the merits of the claim, nor, under the law, should he have been doing so.
Well, we haven't really looked at your criticisms of the claimant's pleading, because the judge said it was perfectly good pleading and you've not challenged that. But the fact that there was quite an argument about that, does that not suggest that the merits of the claim were in play?
Well, no. The reason I criticised the particulars was I said that it was a factor to be taken into account in all the circumstances of the case. It was an alternative. If you forgive me, it was. I think it was an alternative submission, which was against. It was against the background of the fact that we weren't looking at the merits, that there was not a defence before the court that dealt with those particulars of claim, and therefore whether or not they were very strong or not was not something that the judge ought to take into account.
Okay, thank you.
So against that background, a lack of discussion on negligence or breach, I turn to my third point, and that is that the judge did not just rely on the admission and merits separately. The judge relied on the admission not as a matter of fact, as a circumstance that he could take into account in all the circumstances, but he relied on the admission so as to form a view about the merits. And in my submission, that can be seen in his judgment at paragraphs 29 through to 31 on page 80 of the bundle. And I realise that we've looked at these paragraphs, but against the background of what the judge was doing with the admission, I think it's quite important. We can see that the judge is saying that he doesn't think the admission is irrelevant, and it is permissible when those principles are being considered and the court is concerned with all the circumstances of the case to pay regard to whether a party's case is very strong or very weak. So he's looking at the admission so as to answer the question on merits. And then at 30 he says, it seems to me where an admission has been made, as he says, after consideration of the relevant facts, admission may have some potential significance in considering all the circumstances of the case because it may give an indication as to whether the case is very strong. Well, again, the admission is being relied upon in order to answer a question which I say shouldn't have been raised, which is the merits of the case. And again, at 31 at the end, you are entitled to look at an admission in the context of considering whether a case is very strong or very weak, albeit that it's not appropriate to embark on a detailed investigation of the merits. And the judge returns to this at paragraphs 51 and 52, which are on page 84 of your bundle. And we can see at the bottom of paragraph 51, on liability, politely, it's difficult to see how we're not talking about merits when we're talking about liability, but on liability, it seems to me that if one combines the fact of the admission, the fact of the factual basis for withdrawing it has not been explained, the nature of the factual case of answer in the particulars of claim, and the fact of the non-evidence as to what the defence would be on liability, this is a case where, at least on the present material, the claimant's case does appear to be very strong. So the judge is using the admission and the lack of a defence in order to come to a conclusion that the claimant's case is very strong. And in my view, that was clearly the basis on which he was approaching all the circumstances balance. And in my view, we ought not to have been looking at the merits at all. And
why was the judge referring to ISAJ at all? What was the relevance of that case?
Well, in my submission, it was irrelevant. He was referring to it because the way that the submissions were made, we initially went to the notes at 3.9.20, and of course at 3.9.20, both HISAJ and the Global Torch case are referred to. And in my submission, what slightly wrong-footed him was the fact that there was no distinction made by the judge that HISAJ is a permission to extend time for service of a notice of appeal, whereas Global Torch was permission to effectively undo an unless order in relation to merits of a claim or a defence. And so, in my view,
But they're both to do with the relevance or the potential relevance of the merits of the claim.
They
so
are.
The fact that those cases were cited to him and he referred to them.
Well, I didn't cite HISAJ to him. I was firmly in reliance on the, in my submission, very clear test set out in the Supreme Court. I do say there is a distinction, a logical distinction between those two tests, and I alluded to it earlier, namely that when one is looking at the merits of a claim or a defence, one has to look at the ultimate merits overall to see whether or not you can reach a summary judgment threshold. When one is looking at the merits or otherwise of the grounds of appeal, when all the evidence is already before the court, it is much, if there is any distinction to be made between those two tests, then in my submission, the very strong or very weak only applies to grounds of appeal, because logically the court has all the information before it in order to make that assessment without too much investigation.
Isn't it a bit simpler than that? I mean, you can look at the potential ultimate outcome in either case. It's just that when you're talking about an application for permission to appeal, by definition, there's no ability to seek a summary determination of that.
Quite.
So inevitably, one might look for different words to express a concept, which in the case of normal first instance proceedings is expressed in the sort of summary judgment test.
Of course. And of course, the rationale of Lord Neuberger's decision in Global Torch was effectively that if you do get over the threshold of summary judgment, or it is a case that gets over the threshold of summary judgment, then that is not a case that would go to trial anyway. And so that should feature when you're balancing the factors in relief. If you are not, and therefore we don't know what's going to come out in the wash, in a defence, in witness evidence, in expert evidence, one ought not to be undertaking that exercise at a moment in time in a microcosm, because of course you don't have all the full facts by the time you've got to a trial. And in my respectful submission, that is, if we look at, and this is my fourth point happily, naturally, but if we look at the test, I say the test is very clearly set out in Global Torch, and it is important to read paragraphs 29 through to 34 together. And I say that the test is summary judgment. Very strong is not sufficient. And we can see that because at paragraph 32, Your Lordship was quite right, that the submission, I think Mr. Fenwick was trying to broaden that exception by saying, well, hang on a minute, if nevertheless the case was a very strong one such that it would warrant a security for costs order, a conditional order, well, might that not be enough? And we can see at paragraph 32 that Lord Neuberger says no. I should add that I do not think it would be enough for a party to show that while his arguments were not strong enough to satisfy summary judgment, his arguments were strong enough to justify the other party being required to bring the disputed sum into court. For present purposes, as with an outright order for summary judgment, a claim or defence is either unanswerable or it is not. And then over the page, he says, neither as a matter of principle nor as a matter of practicality would it be appropriate to extend the exception to such a case. So in that decision, the Prince was saying, I don't get over the summary judgment threshold, but I do nevertheless have a very strong case. And there, Lord Neuberger was saying, well, that's not enough. It's either unanswerable or it's not. It's summary judgment or it's not. And in my view, if that is the test, that clearly is not the test that was being applied by Mr. Justice Jacobs in the final sentence of paragraph 29 of his judgment. So just picking up on one small point from my learned friend, and Your Lordships happily appear to have dealt with it for me, but there is reference throughout paragraph 29 through to 34 to the exception, and not one of a multitude of possible exceptions. My fifth point is, with respect to my learned friend, I don't understand her submission made in oral submissions on summary judgment. At paragraphs 34 and 35 of her skeleton argument, which can be found behind tab 3 of the bundle, on page 39, she says, it's accepted that because the withdrawal of the admission took place before the reformulated rules, the withdrawal was effective. The consequence of this means that the claimant would not be able to gain summary judgment on the basis that there had been an admission. I had understood that she was saying something different in her oral submissions, but in any event, at paragraph 35, final sentence, she says, although it would be unjust to consider a withdrawn admission at summary judgment stage, it would not be unjust to consider an admission in respect of relief from sanctions. Well, in my respectful submission, that's illogical. If the test is one of summary judgment, how can it be unjust to consider a withdrawn admission at a summary judgment stage, but nevertheless take it into account in a relief from sanctions application when the test as to whether or not one ought to be looking at the merits is also in my submission summary judgment? And finally, was just a very short point on case management decisions. I accept, of course, that there is a wide discretion, and my learned friend referred to the case of Abdullah, paragraph 25, which can be found at page 127 of the authorities bundle. But in my respectful submission, that obviously only goes to my ground 3, which is when one is balancing the factors. Of course, the judge has a wide ambit in which to balance those factors. If as a matter, if I am correct on ground 1 or 2, namely erred in law or unjust, then of course that takes it outside the ambit of Abdullah. And we can see that there because paragraph 25, it says, Mr. Thomas's submissions did not include a submission that the judge overlooked any relevant factor or that he took into account irrelevant factors, nor did he suggest that the judge misdirected himself in law. Rather, his submissions were directed to the weight that the judge attributed to any factors. And of course, that's my ground 3, but not my ground 1 and ground 2. my lords, my lady, unless I can assist you any further, those are my submissions.
No, thank you very much, Ms. Boone. Well, thank you both very much, and those sitting behind you, for all your helpful submissions. You won't be surprised to hear that we will be reserving our judgments in this matter. The draft judgments will be sent out in the normal way in order for you to deal with any typographical or minor factual inaccuracies and not an opportunity to re-argue the case, please. If you could remind those involved of the terms of the embargo on the top of the draft. And I'd hope that anything else can be dealt with in writing, any submissions, and hopefully you'll be able to agree in order at the end of the day. Can I thank you both for your very helpful submissions, and without giving any indication at all as to the outcome of this appeal, because of course we've not had our discussions yet. I think from something my Lord Justice Mayles said that this may be your first outing in the Court of Appeal, Miss Corrigan, and might I welcome you to this court and congratulate you on the way that you coped with a barrage of questions, which Miss Boone no doubt is far more used to handling and did with her normal competence. So we're very grateful to both of you. Thank you.
All rise, please.